now it's time to take your legal queries, and to give you the right advice, we have Munish Upadhyay, partner S&G and Partners, Advocates and Solicitors with us. Welcome to the show, Mr. Upadhyay.
Thank you.
And let's start taking your queries. We have Vikash Chandra Thakur on the phone line. Yes, Mr. Thakur, go ahead with your query.
Mr. Upadhyay, I have one query. Because I am calling from Gurgaon. Hello?
Yes, we can hear you. Go ahead with your query.
बस हमने टाइम रेजिडेंस सेक्टर 63 धूत इंफ्रा लिमिटेड का एक प्रोजेक्ट में बुक किया था.
ओके.
और इसका बीबीए इंटर किया हमने फरवरी 2011 में. और एज पर बीबीए शेड्यूल टाइम ऑफ डिलीवरी मार्च 2014 था.
ओके.
विथ द ग्रेस पीरियड ऑफ 3 months फॉर ऑक्यूपेशन सर्टिफिकेट. एज पर बीबीए 18% इंटरेस्ट अमाउंट फॉर डिले ऑफ पोजीशन, ये मेंशन किया हुआ है. डिले ऑफ पेमेंट.
जी.
तो अभी तक बिल्डर ने हमसे 95% के आसपास का अमाउंट ले चुका है. तो हम लोगों ने बोला कि चूंकि ये डिले ऑफ पोजीशन हो चुका है, तो आप हमें इंटरेस्ट कंपनसेशन का अमाउंट बताओ कितना होगा. तो बिल्डर ने बोला कि नहीं सर, आपका कोई भी इंटरेस्ट नहीं बन रहा है, क्योंकि सारा जो है ना ड्यू टू फोर्स मेजर है.
ठीक है.
तो फोर्स मेजर है, तो हमने बोला कि बस डिले 2.5 years हो रहा है, तो आपका क्या चीज का फोर्स मेजर है हमें बताओ. तो वो बोलने लगा कि नहीं, आपका अप्रूवल में ये प्रॉब्लम था, अप्रूवल में ये प्रॉब्लम था, जो भी है. तो हम लोग सर ये 400 का एक सोसाइटी है, जिसमें आधे मेंबर्स ये करते हैं कि आफ्टर पोजीशन हम लोग उस पर लीगल लिटिगेशन कर सकते हैं. और कुछ आदमी का ये है कि नहीं, अभी हम बिफोर पोजीशन अगर करेंगे तो हमारा ज्यादा क्लेम बनेगा और ज्यादा स्ट्रांग रहेंगे कोर्ट में. तो हम ये आपके एक्सपर्ट से ये जानना चाहते हैं कि हम अभी कोर्ट जाएंगे तब बेनिफिशियल है, या आफ्टर ऑफर ऑफ पोजीशन एक्सेप्ट करने के बाद जाने से बेनिफिशियल.
ठीक है, हम आपको बताएंगे कौन सा बेस्ट सिनेरियो आपके लिए होगा. सो मिस्टर मुनीश उपाध्याय, व्हाट डू यू सजेस्ट, बिकॉज दिस प्रॉब्लम इज हैपनिंग एवरीवेयर, वेयर बायर्स आर कंफ्यूज्ड वेदर दे शुड टेक द पोजेशन फर्स्ट एंड देन फाइल अ केस फॉर द कंपनसेशन, और दे शुड गो बिफोर हैंड. व्हाट डू यू से?
See, Mr. Thakur, there is no problem. It is very good, first of all, that at least you have got this 18% penal interest for the delay period in your builder-buyer agreement. And so far as this story of force majeure on the part of builder goes, I don't think so this story will hold very good in a court of law. So I believe that if the possession is around the corner, say in a month or in couple of months, then be smart, take the possession first and then file for the case. Because builder may eventually delay it in case you file it right now. But if the possession is far away, say a couple of years away, then don't wait for it, because you have no idea whether it will take 1 year, 2 years or 3 years more. Straight away file, make a group of people, file it in the consumer forum. At least you are entitled for this 18% penal interest, which is quite a sum.
Okay, so that advice you should keep in mind, because it's happening widely that the buyers are facing issue with their developers. The possession is not getting on time. Okay, so next query is from Manish Gupta via email. It says that more than 50 families in Supertech are affected by this issue, and it says that none of the good societies have genset in open. Genset should be placed properly in enclosed area, but Supertech has done encroachment of green area and placed genset in open. The second point he has raised is that placed genset are not following pollution board norm. Non-compliance letter is already being issued and by the pollution board. So far no action has been taken by Supertech. And the third point he has raised that there should be a proper pollution air exhaust arrangement is that above building height. Non-awareness of Supertech management is affecting nearby towers and society, and he wants to know what action he can take. What do you suggest, Mr. Upadhyay?
Mr. Gupta, here I think Supertech has done wrong on every single count. First of all, they cannot place the gensets in a green area for which they have charged you. They are open areas for the consumption of the public who have got the flats, booked the flats. So what you can do is, you can all file a consumer complaint, you being the consumer, against the builder, that he is creating a nuisance of this kind and utilizing the area which is meant for the green areas and place genset thereon. Second, you should file a complaint before the State Pollution Control Board, because you have got clear cut rules governing the rules which have been formed by the Ministry of Environment and Forest, and also you have got NGT ruling in this regard, regarding the size of the gensets and also how they are to be placed, how old they are supposed to be, what height they are supposed to have for the chimneys and everything. So, there is a crystal clear violation by Supertech in this. You can file a complaint with the State Pollution Control Board, and the Pollution Control Board will send a notice to Supertech. If they still do not adhere, then Pollution Control Board has got a right to file an FIR against the builder. So, these are two remedies you should do. You should approach a consumer forum and also file a complaint with the Pollution Control Board.
Okay, I hope it will solve your problem. Next we have NK Sapra on the phone line. Go ahead with your query.
Sir, good evening.
Good evening.
Sir, can you listen to me?
Yes, I can hear you. You can go ahead.
Sir, sir, actually we are a group of around 300 people. We all are employees of a public sector general insurance company.
Okay.
So, in the year 2010, we booked flats with Gardenia India Limited. The name of the project is Gardenia Gateway in Sector 75, Noida.
Okay.
So, as per the agreement, builder has to give possession in the year December 2013. And we paid almost more than 80% up to the December 2012, and 95% payment, including the payment for other facilities like swimming pool, gym, and club, etc. That was also paid up to December 2013. Even there was no delay on our part for the payment.
Okay.
So now a few queries. One, builder basically he is offering key possession to us from last 2 years.
Okay.
Without obtaining completion certificate from the Noida Authority.
Okay.
And secondly, he is a defaulter to Noida Authority, so he is not in a position to, because being a defaulter, he is not in a position to take basically completion certificate from the Noida Authority. Moreover, he is a defaulter to Union Bank of India also, from where he has taken a loan above 78 crores. And now the properties, basically the Union Bank of India has taken the symbolic possession of the property.
Okay.
And all of the buyers are badly affected because he is a defaulter to Noida Authority, he is a defaulter to Union Bank of India. And there is one more. We are concerned how this Union Bank of India has this sanctioned loan to this builder, because all of the flats which we have bought, these are already mortgaged with the respective banks from where we have taken the loan.
Okay.
So the property which is already mortgaged, how another public sector bank has given loan to the builder on that property, and how he can take the symbolic possession of the property.
Okay, we'll help you on that. So it's a very big concern that the land to the builder is on lease, and he wants to know that can the bank give him the loan? What do you think, Mr. Upadhyay?
See, Mr. Sapra, we will have to bifurcate your queries just to make it simple. I'll tell you, all the land in Noida is leasehold. The land is allotted to the builder on a leasehold basis by the Noida Authority. Builder has to pay certain premium for the land, and then you have got EMIs to be paid by the builder over a period of time. So, builder is well within his right to take a loan for the construction of the project, and they have to take an NOC from Noida Authority for the construction of the project. So, there is no problem in that. You are saying that the builder has defaulted to the Noida Authority on his premium payment, and again to the bank also, for which he has taken a loan for the construction of the project. Then he has allotted certain flats to individuals, and the individuals have also taken loan against those flats from the banks. There is no problem in that also. So far as your right on those flats are concerned, your right on the individual units are paramount, because builder, before giving any right for those banks to mortgage this property, would have issued an NOC for your flats to Union Bank of India, and then Union Bank of India would have given this NOC. So, your flats, your charge on those flats, your bank's charge on those flats are supreme. To answer your query, today your flats will not go either to Noida Authority or to the builder before the charge of your bank is satisfied, A, or you get some compensation from the builder and builder pays you back the loan amount. And just to answer your query again, ultimately builder will have to make the payment to the Noida Authority and also to Union Bank of India. So, it is quite a complicated case in this respect. You will have to go through your builder buyer agreement also, and you have to approach the consumer forum and bring all this to their notice. But I can give you one word of advice, that consumer courts are very favorable to the individual flat owners, because you are not party to the builder defaulting to Noida authority or to the parent bank. So your interest in any which way will be protected by the consumer forum. Don't delay it, go and approach the consumer forum.
Okay, that's the advice you should follow. Just go to the consumer court and file in your case and get the required judgment. Thank you so much, Mr. Munish Upadhyay, for giving your valuable suggestions and inputs to our viewers. Thank you so much for joining us.
Thank you.